Thank you.
Justice Kagan?
Yeah, if you could just talk a little bit about that, because as I understood it, for example, I read recently that the hospital that has the greatest emergency room services in Idaho has, just in the few months that this has been in place, had to airlift 6 pregnant women to neighboring states, whereas in the prior year, they did 1 the entire year. So if Mr. Turner is right about what the state is trying to convey to hospitals about when they'll be prosecuted, like, why is this happening?
I think that the reason this is happening is because those doctors can look at the text of the statute itself. They can look at the Idaho Supreme Court's decision, which made clear, very clear, that this was a departure from prior Idaho laws that tracked EMTALA. And they can recognize that their livelihood is on the line, their medical license, their ability to practice medicine, their freedom if they have to go to jail and serve one of these minimum 2-year sentences of imprisonment, and they simply cannot provide the care, even consistent with their subjective medical judgment, because as a matter of medical reality, for many of these conditions, it's not yet putting a woman at the brink of death or necessary to prevent her death, yet they know that the standard of care is to provide her with termination, because she is just going to get worse and worse and worse if they wait it out. And the other important point about this, and I think it goes back to this dual stabilization idea, is that tragically, in many of these cases, the pregnancy is lost. There's not going to be any way to save that fetus, because a woman who has PPROM at 17 weeks, there is no medical way to sustain the pregnancy to give the fetus a chance. So in that situation, what Idaho is doing is waiting for women to wait and deteriorate and suffer the lifelong health consequences with no possible upside for the fetus. It just stacks tragedy upon tragedy.
And it can't be the appropriate, it's become transfer is the appropriate standard of care in Idaho, but it can't be the right standard of care to force somebody onto a helicopter.
And it's entirely inconsistent with what Congress was trying to do in the statute. One of the primary motivators here was to prevent patient dumping. The idea was, we don't want people to have to go somewhere else to get their care. You go to the first emergency room in your state, and they have to treat you and stabilize you. But this effectively allows states to take any particular treatment they don't want their hospitals to provide and dump those patients out of state. And you can imagine what would happen if every state started to take this approach.
A question on the spending clause, questions that you've been asked. I mean, what would, if you accepted some of these theories, what would the consequences of something like that be that we would have to worry about?
I think that it would call into question any number of federal spending statutes that provide funds to private parties, and there are a bunch of them. There's the Medicare system itself, which is, of course, a major federal spending program. There are funds provided under Title VI, under Title IX, a lot of federal statutes out there that give funds to private parties and insist on conditions of compliance with the federal funding restrictions. And if the court were to suddenly say that can't preempt contrary state law, then I think that it would seriously interfere with the ability of the federal government to get its benefit of the bargain in those spending programs.
And you mentioned before that this question has never been a part of this case.
That's right. They did not make these arguments in the lower court. They briefly referred to the spending clause, but I don't understand them to have pressed this argument specifically. And so I think that the lower courts did not address it. I think the district court said in a footnote, they briefly referred to it in a footnote of their brief, and it's essentially waived.
Thank you.
Justice Kavanaugh?
You've touched on what's happening on the ground, and that's an important consideration and answer to the question of what's happening. But Idaho is representing, and I just want to get your answer on this, that, as I counted, 9 conditions that have been identified by the government where EMTALA would require that an abortion be available. An abortion is available under Idaho law, and that's in the reply brief. Now, are there other conditions? You've ruled out mental health. Are there other conditions you would identify, or are you just saying that that's not really happening on the ground? I think that's part of your answer, but I just want to get a fuller answer on that.
It certainly isn't happening on the ground. These are the conditions that we're worried about. And I think the problem with my friend's theory that Idaho law would permit it is that you just can't square it with the text of the statute. The
What
state
if
of
they're,
Idaho is...
keep going.
Well, I just wanted to say they're not the ultimate authority on what the Idaho law means. That's the Idaho Supreme Court, of course, and it has addressed this issue in the Planned Parenthood case. And I think it's really significant that in Planned Parenthood, the Idaho Supreme Court expressly contrasted this statute with other statutes that contain health life-preserving measures and recognized this was a total departure from that. The legislature wanted to focus exclusively and more narrowly on a necessary to prevent death exception. So I think that essentially means that the Supreme Court of Idaho has already touched on this issue, and it's no wonder then that doctors who are facing these kinds of pregnancy complications, where in their medical judgment it's not necessary to prevent death yet, but the woman is going to suffer serious health consequences, their hands are tied and they can't provide that care under the Idaho law.
If what's on page 8 and 9 of the reply brief were Idaho law, would there be a problem still?
So if we had an authoritative Idaho Supreme Court decision that said Idaho law allows for termination in the circumstances where EMTALA would require it, yes, of course, then the conflict goes away. But I can't imagine the court would say that because, of course, here...
That's not quite what 8 and 9 say, but I take your point on that. Separate question, different category. I think one of the themes on the other side is that this law passed in 1986 was a very important law addressing a very important problem, namely the problem where hospitals were turning away poor and uninsured patients who came in for emergency care. And the idea was that can't happen. We can't allow hospitals in this country to turn away poor and uninsured people in emergencies. But their theme is that the law was not designed contextually to deal with abortion or other specific kinds of care. And so they make a textual argument, but I think they also make a broader contextual argument about the whole idea of what was going on in 1986. I want to make sure, I don't think that's really come up too much. I want to make sure you respond to that.
I appreciate having the chance to address that. So at the outset, I don't think they can square that theory with the text of the statute, which says in no uncertain terms, here is the fundamental guarantee. If you have an emergency medical condition and you go to an ER in this country, they have to stabilize you. They have to give you such treatment as may be necessary within reasonable medical probability to ensure that you don't deteriorate. And yes, Congress did not provide a reticulated list of all possible emergency medical conditions and all possible treatments, but it was very clear that Congress set a baseline national standard of care to ensure that no matter where you live in this country, you can't be declined service and the urgent needs of your medical condition addressed. And, it would be no different if the state had come out and decided to ban epinephrine. That's the singular way to treat anaphylaxis, a severe allergic reaction. That would violate the statute, and we would be up here making exactly the same arguments because Congress didn't want that. If you have anaphylaxis and you go to an ER anywhere around this country, they're going to give you epinephrine, and Congress mandated that. And I don't see any way to try to draw lines around to exclude pregnancy complications in the very narrow but tragic circumstances where the only way to address the woman's condition and prevent material deterioration is for the pregnancy to end.
Thank you.
Justice Barrett?
So, General, I understand the primary difference between EMTALA and the Idaho statute to be this health. That Idaho focuses on the risk of life, but the federal government says that EMTALA says that the health is, am I right? It's health and life.
That's the principal difference, but I think it's also the difference between necessary to prevent death versus the health concerns would be reasonably expected to occur. So I think that is a standard that builds in a little more space for doctors to take action.
Got it. Is the federal government aware of any state other than Idaho that has a law that does not take health into account?
There are 6 other states that have severe abortion restrictions without a health exception. So I think that those are the primary category of states we're concerned about here.
Thank you.
I should make clear that there are some pending judicial challenges in those states, and so their laws are not always enforceable or in effect right now.
And besides Texas, has the federal government brought suits similar to the one brought in Idaho and Texas and any of these other states?
To be clear, Texas was not our affirmative
Right.
litigation. They sued us, but we have not brought affirmative litigation in other states. And I think this case has been on a course, and Idaho's law was particularly severe because at the point at which we sued, it seemed to cover ectopic pregnancy, and the state conceded that. Now, they have modified the law to exclude that, but it was one of the most pressing concerns because of that.
Thank you.
Justice Jackson?
General,